Hey guys, my name is Joel Williams. I'm a Georgia trial attorney, and today I want to talk to you about whether you have to pay back liens or subrogation claims when you have a personal injury lawsuit in the state of Georgia. If this video is helpful to you, we'd appreciate you liking the video, sharing it to your friends, or subscribing to our page, or just let us know in the comments below. So in Georgia, when you have a personal injury claim, whether you have to pay back any liens from health insurance companies or ERISA plans depends on whether your plan or insurance company is controlled by federal law or Georgia law. If you have what's called a self-funded ERISA plan, federal law controls, and you're likely going to have to pay back your health plan any money it paid on your behalf due to the injuries you received from somebody else. If, however, your health insurance is really insurance, in other words, it's not self-funded by you or your employer, it's an insurance company providing you with benefits, then Georgia law controls, and in order for you to have to pay back the amount that your health insurance company pays, then you would have to be made whole for all of your economic and non-economic damages through your settlement or recovery. This is often very difficult for an insurance company to prove because if you settle your case, you are often taking into account many different factors and many different variables other than the total amount of your damages. There are other situations where you really need to know whether you have to pay back a health insurance or health plan provider, and that is if you receive Medicare or Medicaid. Medicare has very strict laws on their right to reimbursement if you receive funds from a third party for personal injury. And if you're going to receive future benefits from Medicare even after you settle your case, there are special laws in place that you really need to reach out to an attorney and figure out before you decide to settle your case. Also in Georgia, we'll often see hospitals file liens on your claim. We're here in Cobb County, and Wellstar Health System is one of the biggest hospitals in the county. In nearly every case where somebody goes to their emergency room after a car accident, we see Wellstar file a lien on the claim, and that's just because they kind of want to get greedy and bill the entire amount and make the patient responsible for the entire amount instead of billing the health insurance where they know they're going to have to take a reduced rate. In these situations where the hospital files a lien on your claim, it's very important that you seek the advice of an attorney familiar with these laws, because you could get in a lot of trouble if you take money or settle your case without addressing the lien. Before you decide to resolve your case or settle, you really need to know whether there's any liens or subrogation claims out there. I've seen in several situations where someone has accepted a lowball offer from an insurance company of say $10,000, and then they come to find out that they have a hospital lien in place for $12,000. Well, guess what happens? The person takes the $10,000 from the automobile insurance carrier, then they have to turn around and turn that money right over to the hospital to try and satisfy that lien, and they get nothing. If you're not aware of Georgia's laws concerning the right of reimbursement of health insurance companies as well as health care plans, you could find yourself in an unfortunate situation of getting nothing if you settle your case without the advice of an attorney. If you have a personal injury claim, whether it be a car wreck, a slip and fall, anything of that nature, and you want to make sure that you do it the right way, reach out to us at Joel Williams Law in Kennesaw, Georgia at 404-389-1035, or you can reach us on the web at gatrialattorney.com.